night. This is U.S. immigration attorney Sharifa Tharp. I'm here live to take your U.S. immigration related questions. And I also have a great topic tonight. So, what I usually talk about in consults, or one of the major complaints that I get when I am dealing with consultations, is that scenario where somebody is here, they're here with their US citizen or permanent resident spouse, and that spouse has either applied and they're refusing to cooperate now with the green card process, or they've applied and they won't give them any information, or they've told a lie that they have applied for them to get the green card, their spouse to get the green card, but nothing is happening. Or they just will not apply at all, right? They have not applied for them at all. And there is a solution in this case. In most cases, there is a solution for a situation like this. And I'm focusing on solutions and how one can get protections in the United States to be able to continue to live and work here. And this allows an immigrant who is married to a US citizen or a permanent resident who is going through something like this to be able to apply on their own in a confidential process called VAWA. Now, if you followed me, you know about VAWA, but I'm here to talk about this specific scenario because a lot of people think that because they've already applied for the marriage-based case through their US citizen spouse or their permanent resident spouse, that they cannot then turn around and find a process that they can apply without involving that spouse. And so this is the process that I'm going to tell you about. There is a way to switch from the marriage-based process to a confidential process where you can continue to get the green card. Now, this also resolves the issue where the spouse claims they have applied, but you're not seeing anything happen, or where the spouse has applied, but they're not cooperating. And here's what I want to give you some food for thought here. Because one of the situations, the tragic situations that I see with this situation, with this is the spouse will apply for the immigrant spouse, and then they will go and sneak and even withdraw the petition. And they won't tell the spouse. I have multiple cases where that has been the case, right? Where they withdraw the petition and they secretly do it. Or they go to the interview, you go through the entire process, you get to the interview, and your spouse then starts to sabotage you at the interview. I've seen that happen as well. And there are solutions for this. So one, here's what I say. Don't let it get that far. Don't let it get as far as them withdrawing a petition and potentially sabotaging you by telling immigration lies about you. Don't let it get as far as the interview where they can go to the interview and sabotage you, where the immigration officer walks away thinking that you have a set up marriage because of the way that your spouse conducted themselves in the interview. That becomes very dangerous. And while we have won those cases, they become complicated and they are prone to more questions and further review. So your job, what you should be doing to look out for your best interest is to make sure if you have that gut feeling that you can't trust your spouse, follow your gut feeling. One, get in touch with us, schedule that appointment so that we can talk about this. We can strategize. I've been strategizing with clients all week, and it makes me so excited and fired up because I'm strategizing with clients in order to get them the protection and for them to continue to move forward in their immigration process. So I want to be on here to tell you about this so that you don't forget about this solution, that this solution is here, and you should always look to this solution when you're being mistreated by your spouse. And by the way, when they're refusing to apply for you, they're lying to you about the application process. They're using your immigration status against you. that qualifies as mistreatment, and you can qualify to get protection here. Now, what does VAWA do? How does VAWA work? Now, with VAWA, what we do is we put forth the documents to be able to, we put forth documents to be able to show that our client, who is the immigrant spouse, is going through this type of mistreatment. And then once we apply, you will get scheduled for biometrics, and you will get what's called a prima facie determination notice. Now, what that does is that allows you to seek certain types of relief, just depending on the state, based on the prima facie. And it also, what is immigration's way of saying they have initially reviewed your application, they believe that you do qualify if all the facts are true here. And while they put it in line to be reviewed in detail, they're going to continue to give you this prima facie determination notice. So it is a very reassuring document to have. And usually it means the next step is you will be getting your work permit and your travel document if you applied for the adjustment of status along with it. Now, the adjustment of status on the work permit, the processing times vary. However, we are looking at an average of 6 months to 12 months to be able to get the work permit and the travel document. The work permit and the travel document allows you to continue to get protection, continue to work legally, continue to move forward with this process, all in your control, until a final decision is made in the VAWA. Once a final decision is made and you've applied for adjustment of status, they automatically move you on to get your green card. We have several clients who have won these types of cases. They're now green card holders, and they are happy. They are happy and moving on with their lives because they were able to take this route. And I would say that they were wise enough to take my advice and jump on this opportunity. It's not too late, though. This opportunity is still there. There is still the ability to apply for this. It is still a confidential process, and it still allows you to get protections while you wait for your process to be completed to the green card stage. So talk to us. That's number one. My schedule is filling up very quickly, so I urge you to go ahead, call the office, schedule your appointment so that we can talk about what your situation looks like. Now, I just saw what is the cost of consulting with you? My daughter's stepmom sabotaged her I-485. It also applies to parents and step-parents. If parents and step-parents are mistreating their child, permanent resident or a U.S. citizen, they can also apply for this VAWA. So keep that in mind. This also applies for parents of U.S. citizens who are age 21 or older. If the U.S. citizen, son or daughter, is sabotaging your process, mistreating you, refusing to help you in your process, then you need to talk to us because you may be able to move forward in your process. This is confidential, which means it's not about penalizing the permanent resident or the U.S. citizen. Immigration is not there to penalize them. Immigration is looking at the evidence to determine whether you qualify for the relief that can help you to move forward in your life. So what is the cost of consulting with you? My daughter's stepmom sabotaged her I-485. So go ahead and give the office a call. It's $250 for the initial consultation. So go ahead and give us a call and let's talk and get started on a process that can help to protect you. Okay, can a VAWA awardee file for their non-immigrant parents? No. The great thing though is a VAWA, someone who has received VAWA, who then receives their green card, who then becomes a U.S. citizen, can file for their parents. So eventually you continue on the path to U.S. citizenship, you can apply for your parents to get the green card as well. So you continue on that journey, and the first step is to actually move forward to the VAWA process. My brother is in need of information on his process. He has this problem. So give us a call. Now, one thing I want to say here is when you are having an issue with your spouse or your parents where they are sabotaging your process, they're not applying, they said they applied, they're not giving you information, they're using it over your head, it's urgent at this point. I'm telling you, it's urgent because they could be doing anything. They could be reporting you to ICE. They could be writing to USCIS to tell them all sorts of lies about you. They could be writing to USCIS to cancel your process secretly. I take it from me because I have seen it, guys. And while we have helped immigrants to resolve these issues, it takes time to fix. And it certainly is not a good feeling as you're going through it, right? Because once you find out that they've reported you to ICE or that they're writing to USCIS to get you to cancel your papers, or writing to USCIS to tell them a lie that's going to get you inadmissible. While that is happening in the moment, it feels uncertain. It feels like your whole future is at risk and you feel out of control. Well, this VAWA process puts you back in control. But the earlier you get to this process, the better, right? Now, with my clients who have switched the process, I can tell you it's so, I feel so good when I see them become so relaxed. They have so much faith in the process after that. And they realize that they really don't have anything to lose. They would have had more to lose staying with that spouse in that process or believing in the spouse than moving forward with the VAWA process. So very important that you understand the urgency of this situation and the urgency to jump on it. Follow your gut, and look at the red flags. Don't ignore the red flags. Don't stick it out because you think that's the only way. You have options. All right. So now, with that being said, I've given you a whole spiel on the VAWA process and one way in which you can gain control to continue on the path to permanent residence. Here's what I'm going to do. I'm going to answer questions. So I see a number of questions coming in. 3.6 thousand likes on TikTok. Thank you so much for that. It means that this is coming in front of people and people are seeing it to be able to see information that will empower them in their immigration journey. So thank you for that. Now, what I'm going to do is I'm going to answer some questions. I have approved VAWA and I'm outside USA from one of the 75 countries paused. So in this case, I have not seen where the VAWA, the immigrant visa, is exempt from the pause. However, pause does not mean you're ineligible. And while it's frustrating to have a wait, eventually that pause it could be lifted and you can continue your process. So this is where what you did the right thing by applying for VAWA, because it means you're still in the running. It's just we have that pause right now. And we have to, at this time, we have to see if litigation helps to lift that pause, or if eventually they lift the pause, or if the election, based on who wins the election, if that makes a difference as well here. If I have work permit and advanced parole through VAWA, am I still considered undocumented? Now, it doesn't, giving you a work permit and advanced parole through VAWA does not necessarily give you a specific status, but it puts you in a protected. So even though you don't have an official status, you're now protected because you have the work permit and the advanced parole. You're protected while you're going through the process. If I filed VAWA when my son was 16, now he's 19 from Africa, can he still come over through VAWA? Yes, absolutely. So this is a great question. And that's because if you file the VAWA and your children are under 21, they are able to then come over. And for immigration purposes, their age is frozen while you're going through the process. So for immigration purposes, your son will remain being 16 years old until your VAWA is processed and they get to come in. So this is where it's important to apply early and take these into consideration, that your children could also come with you or stay with you in the US. If you have children here in the US with you, because a lot of people I talk to, they think they have to stick it out because their child is also a part of the sponsorship. And so they don't want to, naturally, they don't want to pull out of the process, the green card process with their spouse, in fear that they're compromising their children, which is a totally valid fear. But what I do want to tell you is that your children would be able to apply for the VAWA along with you and get the work permit and the travel document along with you. So you're taking your children with you. You're not leaving them behind and you're not compromising them. They are going to be applying for the process with you. I've been waiting for my VAWA for over 40 months. Think I should continue waiting? Absolutely. In this case, now, if you remarry, keep in mind, if you remarry, you will lose eligibility. So remarrying while you're waiting for VAWA is not an option. But one thing I'm noticing, guys, I'm noticing that people will just talk about marriage as if you can just pick up a spouse at the grocery store. So they'll be like, well, okay, but VAWA, yeah, it sounds good and all, it just takes a little long. So can I just go get married? And I'm just like, how do you just pick up a spouse like that? I mean, I didn't know that it was so easy to just get a spouse and get married and get the marriage-based process, right? I don't think a majority of us are that lucky to find a spouse that fast. And in addition to that, it is reckless thinking, because I kind of have a hunch that when people say that, they are meaning, I'm just gonna go make an arrangement. I'm gonna go get myself a quick spouse or court somebody very quickly and then talk about marriage. And I want to tell you that does not end well. It usually doesn't end well because, one, the VAWA allows you to take full control of your process. You're not depending on anybody. You're not depending on anybody's income. You're not depending on somebody to get you through to the end. And if they get moody and decide that they don't want to help you anymore, then your process is all messed up. The VAWA is only dependent on you. It is your process. And what I find is people jump into marriages very quickly, even if they consider it to be real. They have this quick whirlwind thing going on. They get married because they just want to get to the papers very quickly. And it turns into a disaster because, one, that US citizen senses that there's some desperation for the papers and they start to really milk the heck out of it. So this is where I say, if you're thinking like, oh, I'll just go get married, you may be, jumping from the pot into the fire. It may be a situation like that, right? So look at the options that you truly qualify for and stick with those options, because the last thing you want to do is jump into a quick marriage and put yourself on the radar of immigration to really scrutinize a marriage where, it was just really quick. And sometimes in some cases, a set up marriage, which is not allowed under immigration law, right? So no case is simple. Marriage-based cases are not simple anymore. They are combing through those records and they are really honing into potential fraud. So just keep that in mind. If that's your process, you have it, you have work permit, you have protection while you wait, stay in your process. If I want a work visa, do I have to get a job or apply for a job first? Great question. Now, I help clients who have been taken advantage of by employers because there's this misconception that you come here, you get a job first, and then the employer will sponsor you. Big mistake. Unless you come in with a work visa, the work visa to work for the employer, an employer cannot hire you before you get your papers and then sponsor you afterwards. They cannot do that. If an employer is telling you, come on, come over to the US, come work for me, and then I'll sponsor you, lies. It is not permissible under immigration law. It will get you in trouble. And in many cases, the clients end up being trafficked in situations like this. So, what I always say, guys, to prevent, I represent clients who have already been tricked into situations like this and ultimately have gone through what's called labor trafficking, which just lying to people and telling them that they can sponsor them, so come work, is a form of trafficking by fraud. I've represented clients and gotten them to the process where they end up getting their papers. They get their work permit and their residence here for them and their families. However, it's not a good, of course, it's just a terrible experience to go through. And so I want to prevent people from ending up in these situations where they're tricked and trafficked. And this is what I always say, just keep this line in mind. Papers first, then you work, right? If the employer is saying, come work first, then you get your papers, lies. It's a trick. Don't fall for it. Papers first, then you work, right? And that will tell you the intention, the true intention of the employer. Can my daughter petition for me, although I am from Jamaica, but I'm already in the US? Now, I don't know what your daughter's status is, but let me assume that she is a US citizen. Absolutely. Yes. If you came here with a visa, your daughter's a US citizen. Yes, you're from Jamaica, but here's the deal. You're here in the United States. The pause on the green card through adjustment of status is not applicable while you are in the US. So being here and applying for adjustment of status through your US citizen daughter is going to be your best strategy. It's going to be your best strategy. So make sure that you are talking to an attorney, because I'm not your attorney. I'm just giving general information. That's where you call, you schedule an appointment so that we can talk about your particular situation. But based on these general facts, yes, there is a possibility that you can still move forward. Now, even if you were in Jamaica, and yes, you were subject to the pause, I would say your daughter should still consider submitting a petition, because submitting a petition is going to solidify your position in the process once the pause is lifted. Can Guinean nationality apply for citizenship right now with a 10-year green card? I say apply, even if there's a pause right now. I'd have to check if Guinea's on the list. But if you have a 10-year green card, and now keep in mind, you have a 10-year green card, but if you have been a permanent resident for 5 years, you can apply for citizenship. And I say go for any benefit you qualify, go for it. Even if there's a pause that's applicable, once the pause is lifted, they continue your process, you're already in the running. All right, so now I'm going on to Instagram. Put your questions in the comments on Instagram and I will answer. For a person who is not on the pause list and have a case pending, does the case move forward faster? No, not necessarily. What if someone submitted an EAD but case got closed? So yeah, that's a problem. If the asylum is closed, the EAD then becomes invalid. However, if it just depends on why it was closed. If it was closed because of some sort of administrative issue, maybe there's a way to reapply for it or apply affirmatively. I just don't understand the context. So this is where you definitely should talk to an attorney, and you can always call and talk to us. Or if you file for a divorce while in the process of applying for VAWA, can that be used against you? Well, no, not generally. You can divorce while you're going through the VAWA process. Now, even if you're divorced, by the way, you say you divorce your spouse before you even knew about VAWA. If you have been divorced within the most recent 2 years, so you have been divorced less than 2 years ago, you can still apply for VAWA if your spouse mistreated you. But you can divorce while going through VAWA. Now, can a divorce be held against you? It depends on what's in the divorce, by the way, because these are public records that immigration can access. And so if there is something in the files that's contradicting the VAWA petition, then they definitely can ask questions about that, right? But generally, you can divorce while going through the VAWA process. And I've had many clients do the divorce while going through VAWA, and they came out okay. But it just depends. And this is where it's very important for you to inform your attorney about your VAWA and inform your immigration attorney about the divorce. So if there's any information that needs to be exchanged between the attorneys, that information is shared so that everybody is on the same page. When the VAWA is filed, can one get a work permit and SSN? Absolutely, yes. That usually comes within 6 to 12 months of applying. Do you recommend filing for a divorce while the VAWA is being processed? It's a personal choice, but it can happen. Divorce can be a possibility. It's not my primary focus in regards to the VAWA, because you can file for VAWA whether you're together, separated, or divorced or divorcing. You can still apply for VAWA, but getting a divorce is permissible. Yes, definitely have your brother call because we can help with that. What if someone work permit submitted but their asylum case is closed? Okay, I answered that. Okay, and that's all. Those are all the questions I see. When you file by mail, does it take a while to get the receipt notice? Yes. So I would say at least 2 weeks. It could be more, depending on the case type. We've seen it go as long as 6 months for some case types. How can I have my son live in Baltimore with his grandparents and attend school? He's 7 and he's Jamaican. That would not be a question for me. I think that's more of a personal, logistical type of question. But children are not supposed to be rejected from schools because of their immigration status. Can my pending VAWA still be approved without reckless driving that got dismissed? Yes, it's possible. Absolutely. Your case got dismissed, so there's no conviction, and reckless driving, it really depends on the facts here, but does not usually involve inadmissibility. Thank you so much for the love on TikTok. 10.1K likes. Awesome. Keep it coming so more people can see this information and be empowered, take action with this information. Is VAWA application can only be filed by mail? Yes. So only by mail right now. Can my husband put my son on our papers even though we got married after his 18th birthday? Great question. So your husband if your husband is a US citizen and you married your US citizen spouse after your son turned 18, then they would not qualify to be sponsored as the stepchild of your spouse. So in order to for your spouse to sponsor your child or their stepchild as if they were the child of a US citizen to get through the process faster, you would have had to marry your US citizen spouse before your child turned 18. So keep that in mind if you're thinking about getting married to your US citizen spouse and your children are about to turn 18, don't let them turn 18. Make sure you set the date of marriage before they turn 18 so that they can also be filed for by your spouse. All right, let's see if we have more questions. And then on YouTube, let's do YouTube. I see questions here on YouTube. Thanks so much for your patience, guys. Thank you so much, Veronica. I appreciate that encouragement. Can a VAWA awardee file their, so I answered that. Can they file for their non-immigrant parents? No, not until they become US citizens. Any DACA updates? Not at this time. My husband's petition for my, but he don't want to file the taxes for me to use it. Will that be a problem for me? Now, with your spouse, if your spouse is not cooperating, that's where I'm concerned, right? Your spouse doesn't want to file taxes, that's one thing. But if your spouse is really looking out for your best interest and knows that this is going to be something that immigration is going to look for and it's going to make your case stronger, why wouldn't your spouse do it? And so this is where I say you get individual legal advice about your options, because whenever I hear the spouse not wanting to give documents, not wanting to give taxes, not wanting to do this, not wanting to do that, I don't know any spouse that would do this to their immigrant spouse that would not want to go to the fullest extent to make it possible for their spouse to get their papers. So this concerns me, and I say, give us a call and talk to us individually in a confidential process about your case, and if there is any other action that you can take, like this process, because that's I just don't see how somebody can do that to their spouse. So I need to get the full story for sure. What if your case was sent in by mail and they rejected a document because you filed the old version and requested a new form version, but you haven't received the receipt notice? Is that a bad thing? So if they reject it, they'll let you know they rejected it, and then you can refile it. It's not a bad thing, unless you miss a deadline. But it's usually, you would be fine making the correct filing. How soon can you call them? Only receive receipt notice. It's been 5 months. Now, where I say no biometrics, you can go look at the processing times on uscis.gov. If you're still within the case processing time, then, really wait. If you have a receipt notice, it means that they have your case. Biometrics is taking longer. Receipt notices are taking longer, so it doesn't necessarily mean anything is wrong. My mother got her temporary green card through Amnesty, but she did not complete the process and the card expired in 1990. What can be done now? Give us a call and let's talk about that, because she got a temporary green card. I'd have to understand the context, what this was under. I know you said Amnesty, but I need to understand more about this green card that she got. You said temporary, but is it that she just never got the card and never applied for it? So give us a call. There may be the option to still fix the situation. How can I get my son to live in Baltimore? Okay, so That I cannot answer because it's more about, school, going to school here, um, and living with the grandparents. I wouldn't be able to help with that. If you really want to talk about immigration options, give us a call and schedule. But that is very specific. I'm unable to get to work in my home state. I'm in another state from my spouse. Will that be a problem when I'm removing conditions? It may be. Yes, it could raise as a red flag. Those are the kinds of patterns they're looking for, where you're living apart from your spouse, after, especially if you've done that after getting the green card. So, definitely call us, talk about options. We do remove conditions from 2 year to 10 year. So get in touch with us. I-130 approved, I-485 pending, and I received a notice of certified mail that I have to pick up. What could it be? I'm not sure if you got a notice. I don't know. So you have to pick up what? Because I'm not sure. Yeah, I've not really seen that before, where you have to pick up. Usually you get the green card in the mail. So I would have to see that notice to understand what's going on. What if USCIS is saying they send me back through the border, which they didn't? What becomes of my asylum case while still pending? We'd have to talk to you about the facts here because we need to understand. I'm not sure. If USCIS is claiming you went back through the border, because and should then to say that you didn't have entry, you didn't have admission into the US, then it's a matter of showing that you were admitted. Did you get a parole document? Did you get an I-94 to show that you were admitted or that you were given some form of permission, parole to be here? Do you know anything about taxes? I have a friend and she has a bank account outside of the country. Does she have to report it to the IRS, even though she is the one who put the money in? I am not going to touch that subject. That's very specific, and you definitely need to get tax advice regarding that. So that will not be an immigration issue today. My husband petitioned for my. Okay, so I answered that. All right, an immigration lawyer. Oh, so that's the AI summary. Husband, U visa pending. He has a bona fide and a work permit. Can he petition for me at this stage as derivative? So yes, you can be a derivative on the application. You can submit a derivative and then request the bona fide, the work permit based on a bona fide determination as well. Do you really need an employer to get a TN visa? I'm a Canadian. So I believe you do have to, I'd have to check the regulations, but I do believe an employer letter is required. You have to show that you do have a job prospect to get the visa. I'll have to check though, and then I can come back and confirm. Do you have to go back for an interview to remove the 2 years? Yes, it's some are waived, but like we got one. Well, this was a waiver for the 2 year, but it was going from 2 year to 10 year, and we did not. She was not scheduled for an interview, so they're still waiving some interviews. My dad was denied a visa because of a medical report after I filed for him. Can we refile or appeal? Yes, it's possible. It depends on, now, if you're going to appeal, you have to show that there was some kind of error, mistake, something, error in the law that would justify them approving the appeal. So whether you refile or appeal is going to be dependent on what makes sense. Is it possible for a visiting visa go to America at this time? Yes. Just depends on what country you're from. Did biometrics 3 days ago. What's next? Usually a decision, or if you applied for the work permit, I don't know what case type you did, but whatever you applied for, usually a decision comes afterwards. And if you applied for a work permit, that comes afterwards. But there's also processing times to keep in mind. You can go to uscis.gov, go look up the form that you submitted, and you'll see the case processing times. When you married a US citizen, how long will it take to get a green card? So we've seen green cards come in as little as 3 months, and then also go longer to a year and a half. It just depends. Can file for my husband? He's in the USA. Are you a US citizen? Are you a permanent resident? If so, it's possible to apply for your spouse, but we need to understand more. Like, how did your spouse enter the US? To be what country is your spouse from? To determine whether it's going to make sense. So, can I get married to a US citizen if I'm on a 3-month visa? It's possible, but always consult an immigration attorney. We're here to talk to you about your situation. So give us a call and let's talk and get started on it in a proper way. How long does someone have to be together while they're married, I guess, to file? And there is no limit. So there is no limit. But what they look at is the substance, right? So not so much the quantity, but the quality, right? Are you building a life together? So yeah, if you did a quick marriage in Vegas, for example, you met the Friday, you got married the Sunday, and then would it be a good idea to file on Monday? Probably not. You're going to want to spend time figuring out logistics. Where are the both of you going to live? How are you going to live together? What bills are you going to put in each other's names? Maybe changing some names, getting assets together, putting your financial resources together. Those are going to be the basic things that you would do if you really had a genuine marriage. You would be figuring those things out in the first part of your marriage. That is what immigration is also looking for. They're looking for the genuine process of building your life together. I'm a USA citizen and I think, spouse is from Sierra Leone. If your spouse is in the US, you can apply for them. How much is required for my husband to file for me? US marriage visa. I'm in Nigeria. So you'd have to look at the fee schedule to be able to say. You need 3 different USCIS accounts for petitioner and mom and kid filing within the USA. So if you're filing an I-130, yes, each person is going to need an individual USCIS account. How long will the work permit take to be approved for a case as T visa? Go to uscis.gov, go to case processing times, look up the processing times for the work permit, and then you'll be able to see the range of time that it's taking right now. If I leave the US without getting a green card, how long before I can come back? It depends on whether you overstayed, whether you entered the country without permission. It depends on your immigration history. Were you even ordered deported? That can tell whether you will be barred for 3 years or 20 years. Or whether you'll be barred at all. You may not have to be barred at all. It just depends. Okay, so overstay. And it depends on how long you overstay. If you overstayed 160 days past the date of your legal entry, then it's going to be a 3-year bar at minimum. Is it possible to get a medical visa to the USA from Dominica? Yes, it's possible. I bet it's a bit harder now, of course, but it's possible. Yeah. I'm unable to get a work permit in my home state. I'm in another, so I answered that. Okay, so let's go back to Instagram. Can it cause problem if my husband married was null and he found out his ex-wife has intellectual disability that he never knew about? It's gonna be a problem if your marriage was null and void. It's gonna be a problem. So that, that would have to be fixed, of course. Hello, I'm a permanent resident and I filed for spouse in April 2025. I-130. He's currently visiting on a B1, B2 since January 30. Can I file for an adjustment of status? This is exactly the question that I needed tonight. Yes. So right now we have a current priority date. The status is current, which means that if your spouse is here currently visiting on a B1, B2 visa, they have not overstayed, then you can file for adjustment of status before their time expires. It must be before their time expires. So give us a call. Don't do I've seen many mistakes with this process. So give us a call. Let's talk about you individually because I'm not your attorney. This is general information. So we can talk to you individually to be able to understand your full situation and confirm your spouse qualifies and get on this ASAP. Right now, for the month of April, it is now current and that can change at any time. So get on it. This is the perfect question. Thank you for that question. And that's exciting. If you are the spouse of a permanent resident and you're here right now visiting on a B1, B2 visa, the priority date is current. It means that you can now file an adjustment of status, even if the I-130 hasn't been approved yet. Can it cause problem if my husband's marriage was null and he found out his ex-wife? So I believe I answered that. I'm not sure if the previous marriage was null and void. If the previous marriage was null and void, it shouldn't affect your marriage. But I'm not a family attorney, so this would definitely be the question for a family law attorney or a divorce attorney. But what I, for my purposes, of pushing your case forward would be, is your marriage valid, right? At the end of the day, is your marriage valid? If, for example, the divorce didn't go through well, it means that your marriage probably isn't valid, right? So I would want to confirm, is your marriage current? My son got in trouble at Barbados when he tried to enter America. They refused him entry. What can he do to gain entry again? It's going to depend on what happened. If he has been rendered inadmissible, there are non-immigrant waivers that he may be able to apply for to be able to re-enter. So it won't cause a problem. We currently married right now, but he got the null paper that she had that disability that he never knew about. So this is where I say contact make sure you contact the lawyer, and this is going to be a family law attorney, just to make sure that it didn't affect your marriage. It's been over 8 months. Just did my biometrics for the T visa. How much longer waiting? What I'm telling people to do is go straight to the horse's mouth. Go look at the USCIS case processing times, and that will give you an idea of the maximum amount of time that you'll be waiting for the work permit. The amnesty I mentioned for my mom was done by Ronald Reagan in 1986. She got the card in 1988 for 2 years. The temporary resident card allowed her to live and work in the US. So my thing is, I don't know if I would have to review that because it doesn't sound like a permanent resident card. It sounded more like a temporary authorization. And that since it was so far back, we would definitely have to look into what this is and whether it is a fixable situation. And we can also look at alternative options as well. So that's what we do here as well. We look at alternative options. They spell my name wrong on my green card. Will I be able to travel? I would say get your green card corrected. You usually, if you have to get it corrected, you can get a temporary stamp in your passport. But just to be safe, you shouldn't really be traveling out of the country with a card that doesn't match your identity. I'm a US citizen. My husband is from Sierra Leone. He came with a B1, B2 visa. Can I file for him? I would say you can file for him, but keep in mind that there may be delays or holdups or pauses because of the fact that I'd have to check. But if Sierra Leone is on the list, then there may be a pause, but do not let it stop you from applying, because when the pause gets lifted, then you can move forward where you were. What about if you want to remarry and file I-130? I-360 pending. Should I file immediately after marriage? If your I-360 is pending and you get married, which I-360 is the VAWA, guys, you will no longer qualify for VAWA. So you have to think hard. You have to think hard, and you have to think about this hard, because if you marry this person, get disqualified for VAWA, and then this marriage turns out to not be reliable, or you can't rely on your spouse, then you're back at square one, but now you have no options. So very important to think about whether you want to give up control through the VAWA process to be able to then apply with your spouse. Can I get information on K1 for a beneficiary being in Jamaica? Give us a call, talk to us, and we can talk to you about your particular situation and whether you qualify and what this process is going to look like. Is it possible to apply for change of status? I'm Colombian. Yes, it's possible, but we have to understand your case. How do you qualify? That's what we get to in our appointments. We applied for a non-immigrant waiver, and USCIS rejected his waiver on the basis that he needs to do probation. What can he do? So this is very little information, and we need more. But if he has not completed, there's not a full full adjudication of his criminal process, then they are not going to give the benefit. Is it safe to go for biometrics? Yes, for the most part, it is safe. If you are facing certain risks, like you have removal orders, or you have any kind of criminal records, this is where you have to really make sure you're talking to your attorney to figure out if there are any additional risks to you. I got the stamp on my passport to travel. So if you got the I-551 stamp, which is a temporary green card, that should be good. All right, I'm gonna do last questions, and then I will be out for the night, but aiming to come back tomorrow. So this is what I always say: like, subscribe, follow, share, hit the notification bell. This is what enables you to see when I come on, so that you can come on and ask questions if you're available. What if you're from one of the banned countries? Would that affect your removal of conditions? No, because you're in the US. But here's it: they are pausing. Pausing does not mean stopping or disqualifying you. So you're going to experience a delay, but you should still apply to get your conditions removed. Those who are in the US are not banned, but they are pausing them for right now. What is the next step after getting receipt notice from USCIS stating that your VAWA application was received? So biometrics, which comes if about 2 to 3 months after. Now, keep in mind, estimate. This is an estimate. I am not working at the USCIS. I don't control their processing times, But your biometrics comes next, and then after that, maybe the prima facie, and then after that, the work permit. All right, guys, thank you so much for this time. As always, I appreciate you coming and asking all these great questions. But what the way that you're going to solve your immigration issues or your immigration questions, or you want to go ahead and move forward with your immigration goals, is you must go ahead and talk to an immigration attorney. That is going to be the best move you can make. And we are available to do that. We help immigrants every day. And I've been so excited all week telling people about the options that they had. And people that thought they had no options this week now have hope. They have our backing as the legal team, and they are excited. So I want to get the good vibes from you, and I want to be able to help you. So call, schedule. My schedule is filling up though, so make sure that you're acting fast to get on my schedule so we can talk about those solutions and get started ASAP. All right. Now save your questions. If I didn't get to your questions, please save your questions. And tomorrow when I come on, you can ask those questions again or schedule an appointment. That's where you're really going to get the straight up questions regarding answers and solutions regarding your particular case. Because it's not about sitting behind a computer and asking questions. That's just the start. The goal is to take actions that will make a difference, and that is where you're going to see your results, is to take action. So ask the questions, get advice, then take actions. All right, have a good one, guys. Bye bye. Have a good night.